All right, so that we don't delay further, it's always the day two of any conference is always tricky in the mornings to start on time, but hopefully we can cover up. Um, Welcome to the second day of CPR Dialogues 2020. Most of you've already been in the session in the adjacent hall, and you know from your programs that the lineup for day two is as engaging as the lineup was for yesterday. We have parallel sessions in Jacaranda, which is next door, as well as here in Gulmohar. And my name is Mukta Naik. I'm a fellow at CPR, and I'll be your MC for this room today. I have a couple of housekeeping announcements. This is just sort of part of the deal at conferences. So please keep your mobile phones on silent. If you're tweeting from here, please use our hashtag CPR Dialogues 2020 to amplify conversations. The event is being live streamed as well on Facebook, so it would be useful to amplify that as well. I'd also like to point out that we have a display of CPR books and publications, which you can also, I think some books are on sale as well, so you can look that up, as well as an exhibition titled Field Notes Research to Practice, which is right outside in the hall opposite the adjacent room. The other thing that I'd like to point out is a little bit about the conference kit, just because I didn't get the chance to say this yesterday. But if you look in your kit, you'd see that there are a number of interesting items there. We have bags and notebooks from Choti Si Asha, which is an NGO in Chandigarh, which works to build sustainable livelihoods for underprivileged children. We have brown paper pens from Go Grameen, which is an Ahmedabad-based organization, and we have folders from Papertree, which are made of cotton paper. These are the people who also do Hathi Chap, which is elephant poo paper, which a lot more people know about. So this is just little efforts on behalf of CPR to I think make it more realistic that we can choose alternate materials for things that we usually think we can't. So we'll move on to our first session today, and I think our speaker, external speaker, Mr. Sudhir Krishnaswamy, who's the Vice Chancellor of the National Law School of India University in Bangalore, is on his way. He's a bit delayed, and he'll join in. But the rest of our speakers are here, and I have to say this is my favorite panel from the conference because it's all my lawyer colleagues on the dais here, and one not lawyer, but it's like this powerhouse of CPR fellows. Women who make a lot of difference in the world, who always champion the things that we all want to champion, but much better than us. So let me introduce Namita Wahi, who's a fellow at CPR and director of the Land Rights Initiative at CPR. Shibani Ghosh, also fellow at CPR. Kiran Bhatti, senior fellow at CPR. And the session will be moderated by Arkaja Singh, who's also a fellow here. I'll hand over to you, Arkaja.
Thanks a lot, Mukta. Am I on the mic? I think I am, no? On. It's red for on. Yeah, it's all right. Okay. All right. Okay. All right. So, I mean, we'll start now, and we will. Sudhir will join us. He's probably about 5 or 7 minutes away. I've just spoken to him. So we'll start now, and we've asked him to actually tune into our live stream on print, apparently. But let's see how that works. So. You know, Lant in the last session was talking about the power of ideas, and I think that's a very relevant place to start talking about social and economic rights, because rights don't have, I mean, rights are not only about interest groups. They affect interest groups, but they're not only about interest groups. And we'd like to here shift the frame slightly to talk about the idea of social and economic rights and what they might mean in context of or in relation to the state, because you know that's something we all engage with quite closely in our work. Social and economic rights came into, you know, the Indian Constitution didn't guarantee social and economic rights to start with, and it still does this only in a very limited way. And this interpretation was extended through the vehicle of an Article 21, which protects the right to life and liberty. This has been since the late 70s and the 80s progressively interpreted to include various types of rights. So various sorts of social rights, including the right to food, the right to shelter, the right to water, the right, various sorts of rights have then become interpreted as part of the right to life. And this is the, someone has called this the backdoor entry of social rights into the Indian Constitution. But, it's been seen in different ways, and it's been seen as an idea whose time came about, and therefore the interpretation of the Constitution was extended to increase it, to include it. However, social rights through this Article 21 form are perhaps most relevant in very dire and stark situations, where the denial of a social or economic right is actually a matter of life or death in some way. So we see this in the manual scavenging cases, where we see that the issue was made out to be really stark in terms of human oppression. And the court's interventions here resulted in a very powerful recognition that the continuance of the practice of manual scavenging was a violation of constitutionally protected rights. Before this, the government of India had sort of come around to the idea that manual scavenging was a problem, but it was not being framed as a rights issue. The court's intervention also went further as, to create a new legal framework which helped regulate and control and prohibit various associated practices of manual scavenging. It set up a principle for compensation. All this came well before there was actually statutory law to cover these things. And finally, the interventions of the court prodded the government into creating a more inclusive legal framework, which included many of these practices. And so it's the use of the Article 21 form and the use of the PIL cases did something very powerful on the issue of manual scavenging. In contrast, though, we see the right to water and the right to shelter cases, where the rights that have been recognized are very, very limited rights. And they're often limited to the state agency being told to implement some pre-existing procedure or make some, slightly better procedure. The ones where they work most effectively are actually, the cases where there is already a reasonably generous policy in place, and the court simply says that this policy is applicable to this case, and please apply this policy. So I looked also at the Pani Haq Samiti case, which was hailed as a big right to water case, and people have talked about how the court recognized that the right to water applies to people who are in illegal settlements. However, even here, when you actually look at what the court says, it doesn't say very much more. It says that a person in an illegal dwelling also has a right to water, but the city corporation can make a better policy. By that policy, they can actually make people pay more for the right, pay more for water than people in not so illegal dwellings. And the corporation need not even provide piped water. It can, set up water ATMs or something. So ultimately, it does very little for the people who are claiming that right. On the other hand, however, the Article 21 interventions are not so useful. So, so we have these, there are a whole lot of these, water and shelter cases which sort of go in the same way. And in all of these cases, really the courts are not able to get beyond the issue of illegality of dwelling. So, all of the cases, ultimately the reading of Article 21 is only very, very limited because of the fact that they're not able to get over that legal obstacle. On the other hand, Article 21 interventions are also not so useful against continuing low-grade violations. So in spite of all the important stuff that happened in the manual scavenging cases, it's really impossible in real life to deploy the manual scavenging law unless you have a dead manual scavenger. So the law actually applies to prohibit the practice of manual scavenging, not just cases that result in death. But in fact, this doesn't happen, and the reason why this doesn't happen is, in my understanding, really that there isn't an institutional framework, that takes care of the daily business of sanitation. And so the right that was recognized by the courts, in spite of all the power and salience of that right, doesn't have an operational form. And that means that nobody can really be held accountable for continuing violations in an operational sense. failures in the realization of rights also then, points us to the importance of working on the everyday life of rights. In the examples I've spoken of in manual scavenging, right to water, shelter, that everyday life relates to municipalities and water boards. And can they be held accountable? Can, the people who engage with them in an operational sense, engage with their rules of practice, their sort of norms of administrative behavior, to see how much are they doing to further the interests of equity and justice. So I'm not just talking about defining a core minimum right, but in the kind of everyday operational business of organizations. And perhaps it's in, perhaps the reason why we don't see a lot of right to water cases, for example, in spite of the scale and widespread nature of the problem, is that in real life, people are negotiating this stuff with the institutions at a local level. And it's in that kind of context that, the work of some of my colleagues in, the deep sectoral engagements in, is the real work of rights in an everyday sense. And, at this point, I'll hand over to my colleague Kiran, who will talk about her work in the right to education.
Thanks, Arkaja. So first of all, of course, I'm the only non-lawyer in this group, but it is interesting because I'm going to talk about the right to education, which is in fact the only right that has been codified in the Constitution through a change, through an amendment that made basic education a fundamental right in 2002, following which there is actually an enunciated act, the Right to Education Act, which gives sort of legal thrust to the right to education. But I think the question that we are addressing in relation to social and economic rights, and particularly to the right to education, and the question that continues to be there despite the fact that it is now a full-fledged right in that sense, relates to whether this has actually added in any way value to the education sector or to the realization of the right to education. I think there is still, this question still keeps coming up in different contexts. And it relates because, as Arkaja said, that the Constitution already had the Article 21, and there are many questions about whether there is really a need for the judiciary to be directly implicated, which does happen if you have a legislation like the RTE. Is it essentially an executive function, or is it really is it a matter of sort of negotiation, political negotiation at the local level between citizens and states, or citizens and their political agents? And so as far as the right to education is concerned, really the question we are facing is what difference has it made? Has it made any difference? What has been the experience of the RTE Act? And it's almost a decade now since the act was passed. And I think the simple answer to that question is yes, it has made a difference. And the reason it has made a positive difference, and I think, and the reason that that is the case is that for the first time, the articulation of the act actually tried to define or clarify what the right to education could mean. It has laid out, in a sense, basic standards and norms for the shape and form that a right to education could take. And this was literally done for the first time. And one may have a lot of disagreements on what those standards and norms are. We may not agree that all aspects of what could or should constitute the right to education may have been included in the act in the way that it was drafted or formed. But it nevertheless was the first time that some shape was given to what the operational aspects of a right to education could be. Maybe it is minimal, maybe it doesn't please everybody, but it's that those are works in progress. It is not, it was definitely a very important first step in defining possibly what a right to education could be. Till then, we did not actually have a clear sense of the operational aspects of that right. The second thing, important thing that it did was that it clarified the role of the state, particularly in relation to the non-state. And that also came about actually through a case that went to the courts immediately after the RT Act was passed, and many actors in the non-state, particularly private providers, had a lot of questions about their role and how they had been implicated in the act. And that process itself took the conversation about the role of the state in providing this, in realizing this right to the next step. Several other questions have consequently arisen, but we have definitely moved the needle on getting some clarity on state versus non-state in the realization of some of these rights. But the more important thing, I think, which sometimes one tends not to give that much importance to, is the fact that ultimately the realization of rights is about citizenship. It is about creating democratic spaces. It is about allowing citizens to be able to engage with the state in a kind of more structured fashion. And I think the whole process of having the Constitution amended and of drafting the legislation brought a lot of different actors, stakeholders, if you like, in working in education, civil society, educationists, others, to engage with the state in clarifying some of these issues of what should go into a right and what should not. And eventually, I mean, it was a long process. Even after the Constitution was amended, it took 8 years to draft the RTE Act. And so you can imagine there was a lot of contestation between the citizens and the state in that process. And eventually what emerged was a consensus formulation. And yes, it didn't please everybody. It isn't a perfect legislation. But the process of going through that contestation, in a sense, of the engagement with the state and different actors in the state and in civil society itself is an important process as far as rights are concerned. So I think that it certainly was, so it was, all of those are goods that one must recognize. One often doesn't when one is caught in the nitty-gritty of implementation in terms of realization of individual rights. And yes, as far as individual rights on the ground are concerned, the story is much more complex and the answer isn't a simple yes. But I think there one gets into more murky waters in a sense of state capacity. It is capacity both of the bureaucracy to be able to implement. It is also judicial capacity, I think, that falls short somewhere in terms of both jurisprudence and in terms of the involvement of the legal fraternity. And those are questions that we still need to address. But it doesn't take away from the importance of having actually a legislation that operationalizes or tries to give some clarity to what a right to education may be. And perhaps we can come back to what a state capacity in this regard means later on.
So, moving straight from there to Shibani, who is, can you, yeah. Sorry. I think it's probably 2 mics on or something. Okay.
Thank you, Arkaja. Am I audible? I don't know if the mic is working. Okay, great. Good morning, everyone. So today I thought I'd speak about the right to environment, which has been interpreted as part of Article 21 and the right to life as enumerated in the Constitution, but kind of looking more specifically at a part of the right to environment, which is actually the procedural environmental rights. So what we usually talk about when we talk about right to environment is the right to clean and healthy environment, the right to pollution-free air, right to pollution-free water, right to hygienic surroundings, a kind of an ecological balance, and all those are actually considered to be substantive environmental rights. And most of our kind of academic discussion and also, the jurisprudence has evolved a lot more around these substantive environmental rights. But there are a set of procedural environmental rights which have also been read into Article 21 as well as actually Article 19 of the Constitution by the Supreme Court and followed by several of our high courts and the National Green Tribunal subsequently, which I believe are actually perhaps in some way more important than the substantive environmental rights because they're essential for anyone to actually realize the substantive environmental right, to access the environmental rights. And more than this instrumental role, they're really important, and in fact, Kiran mentioned it, to actually democratize the space. And the procedural environmental rights that I am referring to are specifically 3 environmental rights. One is the right to access environmental information or to be informed, the right to access justice or to have your grievances redressed, and finally, the right to be part of a decision-making process concerning the environment or the right to public consultation. Now, all these 3 rights in some way have been considered to be part of Article 21. But interestingly, these 3 rights have also, apart from this kind of constitutional gravitas that the Supreme Court has given them, do find expression in statutes, in various environmental statutes, as well as a more general statute such as the Right to Information Act, the RT Act of 2005. But what I would like to talk about here is that even though these have been given the rights language in that sense, and courts most recently, in fact, for those of us following the air quality debate and what the Supreme Court has been saying on the issues of air quality in the National Capital Region. The courts, in the case of the stubble burning cases as well as the firecracker cases, the court has very clearly come out saying that this air pollution is actually a violation of our right under Article 21, and this should not be permitted. Go ahead and fine the farmers, go ahead and stop firecrackers, come out with something which is called green firecrackers. We don't really know what those are. Set up smog towers, because apparently there's some science which tells us that they function. Again, that's kind of dubious. But clearly that's coming out of this Article 21 articulation, which the Supreme Court really holds to be sacrosanct. But all that's up there. And what I want to talk about is these three procedural rights, which are actually really real and which is what people really want, is what is in real danger right now. And I'll just give specific examples to show how all these three rights are in real danger and need to be protected. Even though they have found statutory recognition, what they don't have right now is institutional protection. We don't have the institutional capacity, the government backing to actually ensure that all these three rights have been protected. And I'll start with the one which is often, everyone talks about PILs and the right access to justice being a fundamental right. So I'll jump right there. And the way in which the access to justice in the environmental sphere has been in some way been given statutory protection is to set up this special tribunal called the National Green Tribunal. This was set up in 2010. It's a specialized tribunal to give kind of speedy justice in environmental issues, ensure that expert members along with judicial members address what are considered to be fairly complicated issues on environmental conservation, which conventional judiciary perhaps doesn't have either the resource, time, or expertise to resolve. But where is our National Green Tribunal now? It's expected to have 20 judicial members, 20 expert members. For the longest time, it functioned with 4 judicial members and 2 expert members. For several months in the last year, it did not have a chairperson. It still functions suboptimally. It's supposed to have 1 principal bench in Delhi, 4 regional benches in 4 cities of this country. Right now, fully functional, it's only the bench in Delhi, and as of today, Chennai started working 2 weeks ago. The reason is very simple. It's the appointment of the judicial and the expert members. Who has the power to do it? The government has the power to do it. It's an institutional, deliberate weakening of the institution of the National Green Tribunal, which is taking place as we speak. And just by not having a functioning tribunal, you are clearly denying the right to access to justice for those of people who want to raise environmental issues, because the law is very clear. If a case can go to the National Green Tribunal, no other court will entertain it. So even though the high courts and the Supreme Court of the country theoretically can do it under the Constitution, they will not, because they will say you have the remedy under the National Green Tribunal Act, but the tribunal is actually not functioning. So that's one example in which this procedural environmental right to access justice is being clearly denied, and we don't have the institutional capacity to ensure that. Secondly, the issue on right to access information. Now, right to access information, the timely disclosure of information, of course, is essential. Otherwise, the right to access information is, of course, very essential. But it's not just the right to access documents per se, but it has to be timely access to documents. It has to be documents which are essential. These are documents or information which should allow people to actually make decisions, to challenge decisions which affect them. And a clear violation of this is when people really do not know whether, for instance, development projects have been granted any clearance, information about the approvals, conditions on which the approvals were granted were just not disclosed publicly. And then when people want to challenge that and then go to court, the court says, well, you took so long that we cannot now stop the project, and a fait accompli situation is created where these development projects are then allowed to continue. So when you denied access to information initially, you actually, in some sense, the Article 21 right to a clean and healthy environment has been denied, because I really could not have known about the project in the first place. And finally, the right to participate in public consultations. And there are people in this room who have done much more research on this issue than I have, but there have been clear instances. There are, for instance, a public hearing, which is a mandatory required under the EI notification. The project proponent just hires goons to actually to influence people during the public hearing, and they're not able to present what they want to during or raise their concerns. So just by creating this atmosphere where a public hearing statutorily has been arranged for by the regulatory authority, but people can't speak up, they can't express their opinion. So therefore, public consultation, the right to public consultation has clearly been denied. And therefore, again, it's the weakened regulatory authorities who cannot ensure that appropriate public consultation takes place, again, kind of comes in to show that the Article 21 right is not going to be
Kiran, you can't.
sorry, that
Shivani?
clearly, yeah. Okay, so I'll leave it at that. I'm sure we can come back to that in the discussions.
No, Shivani, sorry. We what you want to speak on now? Or do you want to come?
No,
back
I can
to
come
it?
back
Yeah,
to it. That's
yeah,
no problem.
sure,
Yeah.
sure. So I mean, it's something that both Kiran and Shivani are talking about is that when you have a procedural framework, when you have rights that are in a sense operational, the inadequacies of that procedural framework, then there is lots of more work to be done in the inadequacies of that procedural framework, and I think Kiran has some more to say about that. But we'll go first to Namita, who wants to talk about some of her work in the right, relating to the right to health.
Thank you, Arpita. Am I audible? Thank you, Arkaja. We speak so much in policy circles about development that this is a very important and timely opportunity to speak about rights. And so just like for Mukta, this is one of my favorite panels because rights and the Constitution, which is the original social contract that guarantees these rights, are really the reason to bring us all together. And this social contract is between the people of India and the state. And so everything that the state does has to be pursuant to the guarantees that are contained in this social contract. And you'll note that I say people because if you look at the wording of the Constitution, it is between the people of India and the state, not between citizens and state, but between the people of India, and fundamental rights that are guaranteed under the Constitution. Some of them are available only to citizens, but many of them, the most important of them, including the rights to life and equality and personal liberty, are guaranteed to all the people of India. And when we speak about rights, obviously the right to life under Article 21 is clearly the most important. वो कहते हैं ना कि जान है तो जहान है. If you have life, you have the whole world. And so the guarantee of the right to life, even though it is phrased as a negative guarantee, like you cannot be deprived of life and liberty without procedure established by law, has been interpreted by the Supreme Court to include various aspects of the right to life. And here I want to make a distinction between constitutionalization of rights and justiciability of rights, because if we look at the Constitution as the text of the Constitution as it existed in 1950, it in the chapter on directive principles of state policy, it included various obligations on part of the government that included rights relating to the right to health. So just to read out a few, these rights related to safe working conditions for employees, protection of the rights of children to develop in a healthy manner, improving nutrition and public health, care for the elderly, sick and disabled, and rights and obligations to protect and improve the environment. And if we go into the history of the rights movement, how these rights were codified in the Constitution, we find that actually there wasn't so much of a distinction made between civil and political and social and economic rights in the lead up to it. And it is only towards the end that some were made justiciable. By justiciable, I mean judicially enforceable, and some were not. So when we look at the jurisprudence of the right to health, as Arkaja mentioned, it evolved primarily post the 1980s through sort of what people call an activist interpretation of the Supreme Court's decisions. And so we'd done a study where we looked at all litigation on the right to health, over 250 Supreme Court and High Court cases that have been decided over the last 70 years, and supplemented the analysis of the cases with interviews with key informants like the petitioners who brought the cases to court, the judges who decided some of these cases, the lawyers who argued some of these cases, and also got a sense from health policy practitioners as to what was the situation of health in India. And the story and the situation is very, very dismal. Just to put a few facts out there, life expectancy in India is 68 years. according to the World Bank database. 37.2% of India's population is below the poverty line of $1.25 a day. India ranks 131 out of 182 countries on the UNDP Human Development Index. 43% of children in India are underweight, more than the number for all of Africa. India's country rank for under 5 mortality remains at 49 out of 196 countries. But given this dismal situation, you would expect the government would make health really a priority, but that's not true. Total expenditure on health as a percentage of GDP is only 4%, of which government expenditure is only 1%. Our government is spending only 1% on health. And when we look at total expenditure on health in other countries, of course, the developed countries like the US and Switzerland and so on are spending about 16%. But even similarly situated developing countries like Brazil and South Africa spend approximately 8% of the GDP on health. And that's, India is far behind. So in a situation, and so health expenditure is low, health indicators are dismal, and the health policy infrastructure is extremely weak with a lot of, there was initially a commitment towards universal healthcare that was then rolled back, and there's been focus on specific programs. So this is a situation where citizens find themselves, and as we are seeing in the current situation, and what is the remedy for the citizens when the structures that are supposed to give them services that are necessary for their enforcement of their right to health and their right to life, if those are not working, what will they do? They will go to the courts. And that's precisely what we see in the health rights cases. And if you look at the cases that were decided by the Supreme Court and High Courts, Arkaja rightly pointed out that there isn't a core content of any obligation, whether it is a right to water and sanitation, or as Kiran mentioned in terms of initially there wasn't a core content of the right to education that was articulated. But in the case of the right to health, these are all cases that involved egregious suffering or difficulties in accessing public health services. There were 7 major categories of cases involving medical negligence, environmental public health cases, regulation of drugs and vaccines, cases specific to treatment of HIV/AIDS patients, cases about provision of public health services, cases about reproductive rights, particularly rights to the female body with respect to sterilization procedures, rights to mental health, and the rights of workers for health safety at the workplace, as well as many cases are about medical practice regulation. Now, if we look at what comes out of these cases, even though many of these cases may have been brought as individual cases, the court went on to give, the court employs a series of techniques like continuing mandamus and, retained supervisory jurisdiction for a longer period of time. It gave a series of orders, and essentially a large number of these cases, even though they came as cases for individual relief, became public interest cases. And of course, there were many public interest cases. And 84% of the times litigants were likely to win in these cases, which just shows the extent of governmental apathy towards the rights of the people. So essentially, in this situation where the court upheld the petitioner's claims and it gave a series of orders which then became policy. So for instance, if we look in regulation of drugs and vaccines, emergency medical care, we all know that we can now go to any hospital and they cannot deny us emergency medical care. That came out of the Parmanand Katra case in '96. Cases with respect to, there was no policy on regulation of drugs and vaccines, and the Mashelkar committee that was later on set up, it relied upon the Supreme Court. To the extent that even though we have a right to education, there was a draft right to health bill that has been pending with the ministry for a long time. And if you look at the draft that was pending before the ministry, it references the Supreme Court's decisions on right to health and say that these decisions have brought forth the fact that we need to have a law on the right to health. Of course, it has not seen the light of day. So, so to conclude, what the litigation on health rights cases really shows is that essentially we don't really have a lot of discursive spaces to hold the government accountable for its failures on these various fundamental rights. I mean, I'm speaking about the right to health, but this is true of other rights as well. In a situation where, in a parliamentary system, in a parliamentary system in general, particularly in times of majoritarian government, but even in times of coalition governments, the parliament is weak because the executive, in many ways, has comes out of the sort of the ruling formations that are there in parliament. On top of that, we have many ways by which parliamentary procedures which actually limit the ability of minority voices to actually, come before parliament and come together to form a law. So for instance, I've done a lot of work with tribal communities, and even though you have 50 tribal MPs in parliament, you are not able to necessarily get, interests of tribal communities represented in legislation because of the way that parties have to take up issues before parliament. So we have a system where parliament is weak, and parliament is really supposed to be the deliberative and discursive space where these rights can be articulated in legislation, can be, put out and used to hold the executive accountable, but we have a system where that doesn't happen. So in many of these health rights cases, what we see is that the court is providing that discursive space. It is making the government negotiate with petitioners as to why they are not getting their health services in the way that they should.
Namita?
So just last sentence, basically what has health rights litigation succeeded at? It has helped to highlight areas of dire need and improved access to health for very marginalized sections like HIV/AIDS patients and other prisoners, health conditions of prisoners in jail. That's how the first health rights case came about. But at worst, it has failed to bring about structural reform to improve the persistent failures plaguing the health system. There has been no significant increase in health expenditure, and there hasn't been a significant improvement in health infrastructure that has come out of the court's interventions. So I'll stop.
So, I think critically the difference between all these different sort of examples of the extension of the right to life to protect different kinds of social and economic rights, one way to look at it is, to what extent did these interventions shift the policy consensus? How much further were they able to go? Clearly in the right to water and shelter cases, there isn't, some sort of underlying social policy, can we call it, policy consensus or a social consensus about the rights of squatters or people in illegal settlements. Clearly, we don't have that consensus, and that's, that really limits the scope of legal of rights intervention in those kinds of cases. Whereas in the manual scavenging case, in the manual scavenging cases, a large number of cases, and in the health rights cases, the cases seem to have created some sort of, created an articulation of rights that didn't exist before, pushed the envelope perhaps a little bit on the, on the notion of those rights. I'm not quite sure how, the others, another aspect of the story, which is the managerial, the everyday life, the kind of the continuing life of rights after they've been recognized and articulated in the courts. And that's the really difficult space where, even rights that are quite well recognized don't fare very well, and they're, at best, what that legal recognition does is, as Kiran talks about, creates a space within which lots of people, lots of actors can then engage with the state in the everyday interpretation of those rights. But, at worst, we have the NGT case. The NGT cases, or even, even the NGT, even the imperfections of the NGT means that procedural life doesn't, there's still not much that people can do in their engagement with the state if the state doesn't play its part of the story. Moving on to Sudhir, who is a bit late but has, thankfully made it.
Thanks, Arpita. So I'm not going to focus on a single sector, and I'll try and respond to all of the sectors that have been discussed so far, and try and build an analytical framework that we've developed in a book that I call The Qualified Hope, which looks at just the Supreme Court, but across sector, published by the Cambridge University Press in 2019. I think it's agreeable to most that we don't need rights at all for the realization of social welfare goals. Rights are not a necessary ingredient. Having said that, rights have become, in varied contexts, the go-to legal device to push for the advancement of various goals of social welfare. This is not true of all jurisdictions, but may be true of India, at least in the last decade, maybe a decade and a half. So why do we think that juridification should matter? if what we are interested in is, as Arkaja points out in her piece in the print, the safety of sanitation workers, why should juridification, by which I mean 3 discrete processes, legislation, executive action, all forms of delegated legislation, or court action, why is this necessary to ensure the safety of sanitation workers? When we look across jurisdictions, we find very quickly that no matter which issue we take up, whether that be health or education, the evidence that juridification in any of these forms results in better realization, better social outcomes, is mixed at best. Right? So we must state those priors clearly so that we are critically aware that what we are discussing here is not an essential ingredient for social realization, but maybe a strategically important one in particular contexts. So uncovering the social context and other political economy conditions that make juridification important is the critical part of this conversation. So let me run through a few examples of where juridification might matter, and then try to tie it up with a broader analytical summary, not a conclusive one, but at least one that we can that can advance the conversation. So let's take a topic like education. It's something that I worked on a fair bit, and what we find is that the most rapid periods of growth in universal education, if we take universal education to be the real focus of this conversation, occurred during state legislative frameworks. There was juridification in the field of education, but it was primarily state laws that framed the field and state executive action. So that phase of state legislation covers almost 40 years of post-independent India's history. We see the largest advances in the provisioning of universal education under state laws. At a certain time, we enact a central law, by which time enrollment rates are almost at 96, or was it 97%, if I'm not mistaken. By the time the Supreme Court gets into the act and acknowledges that we have a fundamental right to education, I think we're touching the 90% of universal education. And by the time the court starts adjudicating what are known as the important right to education cases, we're at about 98% in the achievement of universal education. I'm saying if you take Unnikrishnan as your cutoff, 1993, the universal education question, at least enrollment, if enrollment is the parameter, we are far along the road by the time the Supreme Court gets to work in Unnikrishnan. So when we look at education and we think about what is the role of the law in education, we have to modestly concede. I say modestly because I know as lawyers we're interested in courts and the Supreme Court in particular, we have to modestly concede that much of the work, the juridical work in education was done before the court got there. And the court's contribution to the progress of universal education may be relevant in some other parameters, but not on the parameter of enrollment, maybe some questions of quality, though the court has actually had very little time to engage with the question of quality education. That's not been the main focus. So just taking education for a moment, what we can quickly summarize is that juridification may matter, but legislation matters more than adjudication, and executive action clearly matters. The most rapid advance in enrollment rates occurs with the adoption of the education policy in the mid-90s and massive expenditures in the field. So it's really executive policy making that drives that process. And juridification matters. It's not clear that rights language takes over at that point. Rights language kind of comes late to the problem. So if we start parsing areas of social action in this way, I think that we develop a better sense of the relationship between juridification and social outcomes. To this, some might say to me that I'm either raising the bar, meaning raising the bar of impact or social outcome. That's the wrong question. Maybe I should be asking other forms of outcomes to be more relevant to assess the work that social and economic rights do. And this I concede. There are many ways of slicing and dicing the question of outcomes and impact. One way, and sort of the hard way, is to look at social outcomes. If the right to education matters, we must have better right to education outcomes. That's a hard test for any court to satisfy and any law to satisfy, because there are many steps between the adjudication outcome and the social outcome, and then controlling for the impact of the adjudication outcome and testing how and showing in a socially scientific, rigorous manner that the adjudication outcome drove the social outcome is quite a difficult task of modeling. And so I take it that maybe we can ask a simpler question. We just asked the question of win-loss ratios, and I thought that the way Namita shaped up the question was just ask the relevant question to us: do we win more, do we lose more? Say on the question of property rights, or on the question of shelter or health, are more often than not are petitioners winning when they challenge state action. This is a fair basis for assessment, but it's a fair basis for assessment of court performance. And maybe, in a juridical sense, what is the jurisprudence of the court? But it's not a fair way of assessing the relationship between juridification and social change more broadly. But win-loss ratios are useful nevertheless, and we should take them into account. And I'll just say one more thing and I'll stop. But a third way of probably framing questions of impact is to not look at material outcomes at all. Maybe we're not interested in win-loss ratios necessarily. As a wonderful article goes, you can succeed without winning. You may lose big cases, but still shift public discourse. And so you can have these discursive wins. We can reframe public policy questions. And these would be broadly bracketed as kind of symbolic outcomes, and maybe non-material outcomes, symbolic outcomes that juridification may generate and may have great value. And it's probably true, and I think it's fair to say that in Indian media debates and in Indian broader, at least legal debates, it's the symbolic outcomes that seem to drive the concern and fascination with the Supreme Court. We seem to both impute to the court, and maybe fairly, the court does have this outsized impact in changing the national conversation. That is, it can simply take an issue like, say, mangrove forests outside Mumbai and reframe what those mangrove forests mean. I don't know. I'm just hypothetically putting it there. Maybe this is the kind of impact that courts have. And in social and economics rights cases, what we're looking for in the adjudication frame is this kind of large symbolic impact, a discursive reframing of the way we think about public policy problems. And on that count, I suppose the court is most successful, if at least for those who see the court as a big player in this field. So let me then trade down my three impacts. If we ask the broad question of social change, at best our court is mixed to poor in guiding big social change. If we ask win-loss ratios, I think depending on the field, in some fields, socially disadvantaged petitioners win significantly in the court, and that's a positive. But it's probably in the third sphere, the symbolic impact sphere, that the court has its maximum play. It gets the attention of headline newspapers and TV every night. So that seems to matter the most. Thank you.
So there's a practical value and a symbolic value to rights. And a practical value, should that practical value also be measured in terms of developmental outcomes, or is that are there other ways to also other considerations for what the practical value might be. And I think and Kiran, what would you say about the both the symbolic and the practical values of the right to education?
Right. So, I mean, Sudhir has already said some stuff about the right to education, and so in a sense, taking off from there. First of all, I think that by the time the right to education came, clearly enrollment was not the concern, but there were many, many other concerns. And those were quite serious concerns because enrollment in any case is a very weak or poor indicator of what is happening in the education space. And the education space was not in a good place at all. I mean, there was attendance was very poor, and I mean, there were all kinds of problems of implementation and in a larger sense of what was happening in education. And I think, as I said, that laying down those standards and norms was to give that shift towards more looking at education in quality terms and not just in terms of enrollment. And I think that the Right to Education Act did that, maybe in a minimal sort of way, but it certainly did that. So it was not just symbolic in giving that message that we needed to have standards and norms and that just anything didn't go in education and enrollment was not the only thing, but it also had an operational side to it. And I think that in terms of, yes, I think there are many, many lessons from that process actually of having drafted the legislation. And I think one of the things that, the takeaways from that is that it is important to have an operationalized framework because it does set those standards and norms. It also sets kind of the roles of the different parts of the state. So, whether it is the courts and it is the executive and also the spaces for citizen-state interaction. And I think the way the Right to Education Act is framed, actually there are many lessons to be learned of how to go about that sort of process. And I think, unfortunately, lawyers were engaged probably in the drafting of the act, because of which there are some loopholes which makes the role of the courts somewhat constrained. It also actually takes away, I mean, I think this is almost unique because we had the National Food Security Act later on and other acts, but it actually does not put any liability on the state in the drafting of the act, and which constrains the courts in a certain way, but it also gives, in a sense, the executive the clean chit. And the famous good faith clause, for instance, actually has given them a complete get out of jail free card, if you like, because it doesn't allow. And to me, it's a big question. I'm not a lawyer, but I don't see the place of a good faith clause in a legislation that is guaranteeing a fundamental right. Because, in a fundamental right, it's not sort of, the state is primarily responsible. So there's, the accountabilities or responsibilities are slightly different in that case. But the Right to Education Act, even though it comes out of a fundamental right, does have the good faith clause. And I think that's worth for the legal community to engage with and think about and how that impacts the role of the court actually in a certain way. But in the operational parts, there were many things that were missing in the way the act is written, because it does not have, for instance, a grievance redress mechanism either. And that constrains the space available to citizens in terms of how they can take up the complaints and what can be done about that. There are, in fact, no institutional spaces created, as Namita was also saying, for that very important part of realizing rights, which is beyond the courts, which is available at the local level, it is available to the states, because in any case, accessing courts is also not easy for an ordinary citizen to do, and so that does limit the juridification part, as Sudhir was saying, and especially for a fundamental right where only the higher judiciary comes into play, it's very hard for ordinary citizens to actually reach even a high court and try and access their rights in that way. So there are a lot of questions related to operationalizing a legislation, even if it's coming out of a fundamental right, but these are not, which doesn't take away from the importance or the value that actually putting it in terms of a articulated legislation, the value that it does add to the space, to the larger space, the social space, or to the political space as well, because it does give a sense of what a right can be. It asks the next level of questions of how to take that forward, whether it is to be taken forward through the courts or whether it is to be taken forward through executive action. And I think the cases that have come up have actually highlighted are interesting. And in here, I just want to give a very quick example where it's not just the symbolic role. It can also have another kind of role, even if it doesn't transform the structures of implementation on the ground. For instance, there have been cases, there was a case actually which started before the RTE was passed and then culminated in the Supreme Court after the RTE was passed regarding the provision of toilets, because The case started with a child who there was no toilet in the school and he had to go home to access the facility, and on the way crossing a highway, he met with an accident and died. But by the time the case came up to the Supreme Court, it was all about the provision of toilets, and because RTE provides for toilets, the court actually asked all state governments to give a report on what the status of toilets in their schools were. And at the time that the case closed in the Supreme Court, 20 state governments, and this is chief secretaries of the state governments, gave affidavits saying that they were fully compliant with toilets and RTE, which is clearly not the case. And even if you look at the official data, you can easily, but the court did not have the capacity to go and collect the hard evidence to prove that that was not the case, given these affidavits. So that matter was closed over there. However, it did provide the opportunity for a group of NGOs in Rajasthan to then take up the case by actually asking children to write small postcards to the Chief Justice in Rajasthan about the fact that they did not have toilets in schools. Yeah. And then the court asked the state government to give a response, and to date the state government has not given a response, but the state government has gone down the line to the district and the blocks where the schools were located and asked the officials to take action, and that action has come about. So here it was not just a symbolic thing. There might have been a symbolic action by the Supreme Court, but actually they did have a real life on the ground impact as well. So I think it's difficult to parse in that sense what the impact even of the courts is. I think it could be at different levels. It could be at the state level, but at the symbolic level, but it could also be on the ground. And so, I mean, again, on a win-lose thing, I think it is a win to have an articulated right, even if it is implicit in the Constitution and implicit in the idea of the Article 21. The fact that Article 21A, which is the right to education, came about as a constitutional amendment, and there is a right that has been articulated, I think has added to the conversations in the education sector and taken them beyond universalizing and
Kiran,
I'd
like to ask Shivani a question about no. I lost my train of thought. So Shibani, one of the reasons why people go to court, and particularly in the environment cases, one of the reasons why people go to court and say right to environment and right to water and right to life is because there isn't anything else to do. There is no other language. So they could be civic violations of pollution control norms. Very simple civic violations, or just the lack of clarity of pollution control norms and no proper, pollution monitoring, no proper work being done by pollution monitoring agencies. And so often, I mean, Article 21 rights are actually, in a sense, weakest in relation to its articulation on environment because of the fact that it's basically addressing, it's basically like a roundabout way of doing something that you could have done directly.
Yeah, you're absolutely right, Arkaja, and I actually wanted to, we talked about the social impact that the courts have. I think there's actually, also when we're talking about this, lawyers need to consider the negative impacts of getting courts into these kind of discussions. Yeah. And when you're talking about weak pollution control boards, I mean, something that some of us are looking at, there's actually evidence to show that once the court steps in, it's almost an excuse for the pollution control boards or the government in power not to step up its game. So it's like, okay, the court told us to do this, so we'll do exactly this and not anymore, even though we're statutorily required to do a lot more. But we're so busy trying to just comply with what the court directed us to do that we are going to put everything else on the back burner. Now, that's a problem in itself, but it's a further problem when what the court asked you to do in the first place is perhaps not the ideal thing. I mean, case in point, a lot of the air quality cases that we're looking at now, the court has now said within 3 months, set up a smog tower. Are we really required to spend all our limited resources, time, and efforts to set up a smog tower where we don't have the scientific evidence to do that? And for another example of, it's just, in this whole thing, just closing off the democratic discussion space by letting the court enter into it. And kind of, in some senses, I think we ignore the fact that the courts have, in some senses, directed the discussion in a particular way, kind of forced the discussion in a particular way, and it could have gone in many other ways. And that's actually a negative impact of the courts, I would say, in articulating it in the rights framework. Yeah. And just come back to your question, and what has then happened is that where we should have actually spent our time and energy in kind of building the capacity of the institutions to do their statutory jobs, they are actually building the capacity to do just what the courts asked them to do. So I think in that way, it's slightly counterproductive. Yeah.
And finally, I mean, another aspect of it which comes up in the right to environment cases and also in the right to health cases is the fact that it is a matter of life and death often, or the issue has to be articulated in a way that's a matter of life and death because of the fact that there is no other way to articulate the issue and no other way to talk of rights. And is that the reason why you have a higher win-loss ratio perhaps in the right to health cases? Whereas, I mean, I don't even know in the environment cases what one would call win or loss because those cases don't actually end and they don't actually have a judgment for anyone.
So, can I also say something about what Sudhir said?
Yes, of course, yeah.
So just to add to what Kiran said, I don't think that the impact of the court is symbolic in nature. I think there's a very tangible, practical impact which we measured in the health rights cases, but I'm sure it can be seen in other cases. And I think, as you mentioned, Arkaja, these are life and death matters, right? So, I mean, are you going to say to the riot victims who were given relief only pursuant to the orders that were passed by Justice Muralidhar that the court's intervention was not important in this particular instance, right? Because we have a complete failure on the part of the central government and the Delhi government, and it's only when the court steps in is some relief provided or some orders given that actually ensure some relief to the victim. So, given that is the context, I always, I completely agree with you, Shivani, that there are many negative impacts of the court's interventions. We see that even in the context of health rights. And for instance, where petitioners have a greater say and the lawyers actually listen to the petitioners and push things in court, and where judges are actually willing to listen. Sometimes judges have also passed orders which don't make any sense on given the ground realities. So, it depends upon how that adjudication happens. But for example, in one of the successful adjudication, which was the HIV/AIDS cases, this is a situation of complete governmental apathy for the people. We had the money was not going to come from the government of India. The money was coming from the global fund. The resources were available, but some policy according to which if you were not already on first line treatment under the government's thing, you would not be entitled to second line treatment. Now we know how government programs are run in India. We know how much awareness there is. There was absolutely no reason for the government to deny second line treatment to people who were not already on first line treatment pursuant to the government's programs, especially when it's not costing the government of India anything. All the money is coming from the global fund. So all this case actually did was to force the government to provide treatment to everyone who needed treatment. And when we talk about vulnerable groups, like many of the cases, I want to highlight that these cases should be looked at as not trying to bring about structural reform, although in the health rights cases we see many areas, like I said, prisoners, healthcare, emergency medical care, blood banks, regulation of drugs, provision of HIV/AIDS treatments, female sterilization, all these areas, actually we did see policies being formulated following the court decisions. But I don't think that is the metric on which we have to evaluate the court's interventions. Who are these people? Prisoners who have no rights, who are actually their right to liberty is also confined. Women who have very poor representation in parliament. We keep lamenting about the fact that the percentage of women in parliament even after 70 years is so low. Emergency medical care, poor people who go to a hospital in the context of an accident and are not given the basic treatment, as a result of which, the petitioner in this case died. I mean, these are instances. So what is the counterfactual? So have the courts have created some problems in enforcement. What was the government doing before the court came in? That is the question that we need to ask. And there I want to actually point to, Sudhir, what you call juridification. I mean, it's an interesting terminology, a little bit different from justiciability. And you say that, this is a critical part of our conversation, and at the same time, rights are not necessary ingredients. I would say that in well-functioning social welfare states, perhaps not. In post-colonial contexts like India, where the colonial state has so much powers and is never really looked at us as the people of India who actually can demand things of the state, but that Mai-Baap Sarkar relationship continues as we had with the British state. I think rights are absolutely essential, and I think that when you evaluate the success of the court's interventions, it has to be against what if the court had not stepped in? Would more people have died, or would more people have survived if the court had not intervened?
Namita, we'll move now to some audience questions.
Sure.
And let's see if we have time to answer those questions satisfactorily. But do we have any questions? Yes, many questions. Okay, so we can start with Manish, then you, sir, then there's a lady at the back. Yeah. Manish, you.
Yeah, thanks for a very interesting panel. I like the way you guys all brought different things together. I want to engage with sort of what I think are two elephants in the room on Article 21. The first is, I mean, this is a panel on socio-economic rights, but the other part of Article 21, which is also its textual part, is the focus on civil and political rights. And the Supreme Court's adjudication on civil and political rights throughout its existence, I think, has been less than satisfactory. And there is one school of thought, which is Bakshi et al., who have argued that the Supreme Court's focus on on socio-economic rights through Article 21 came about as a means to remedy its abdication on civil and political rights earlier. And I think it might be useful to make that link while we're analyzing socio-economic rights even now.
So as a face-saving.
As a face-saving thing. And I think
restore the legitimacy of
so I think with that context and what Sudhir said about the court sort of making this, the third part, right? The court making this statement, this big public sort of creating this big public image of itself and in the media.
Yeah.
The other part, the second elephant in the room, I think, is the PIL, and which all of us are familiar with. Anuj Bhuvania has shown how it has gutted procedure, and what and a lot of this Shibani as well pointed out. But if you take these two things together, I think we see that on Article 21, the court has neither managed to achieve satisfactory outcomes either for civil and political rights or socio-economic rights. And the core of what Article 21 stands for, which is procedure established by law, that idea of due process has sort of, in the end, been thrown under the bus.
Thanks, Manish. So we'll take a few questions. Yeah.
It seems to me that many of the limitations of using Article 21 that have been highlighted here could have been resolved if petitions to the court under Article 21 had been linked to the provisions of Article 2243 under Part 9 of the Constitution, because that provides a mechanism for the execution of whatever decisions may be taken under Article 21 for implementation. That would not depend on the states, it would depend upon the local governments. And since there is conformity legislation on the part of every state of India after the passage of Article 243 in Parliament, you could actually begin at the level of the High Court to check with the specific law of the state, which covers the recommendatory parts of the Constitution and not the mandatory parts of the Constitution. So if that were done, if instead of only relying on Article 21, you were also to evoke Article 243 and the conformity legislation of the state, you could actually begin at the High Court level and hold that state responsible for the implementation of the law that it has itself passed. And then if they fail there, in the Constitution, you go up to the Supreme Court and you say that they are in violation of Article 243. To the best of my knowledge, there is no case law under Article 243, despite its passage more than 25 years ago.
Now, I'll request the questioners to be brief because we have very little time and perhaps 30 seconds per respondent. So there's a lady over there.
Hi, my question
Quickly,
is,
just your question.
my question is Shivani. Was it the statutory intent under the Air Act and the Water Act that the appellate authorities set up under that were accessible to people as well, and not just the companies? And how crucial are these authorities for access to justice?
Yeah. Go on. There's some, Aditya, maybe the girl at the back, and then there's a person here.
In environmental law, but my question is more about the fact that all the activity that we see in the realm of environmental justice or climate justice is always as a collective movement. how much space is there for an individual to come and raise a grievance in front of court? For example, in context of migration in response to climate change. If I can no longer earn a livelihood as a fisherman, can I go to court and say that I need to be moved from here? And they then, or for example, rising sea levels that force me to move somewhere else? These are individual cases, but unless they become a big enough movement, they don't see any face time in front of court at all. Yeah.
Yeah, my question is to the role of judiciary when there exists a conflict between the social and economic rights. For instance, there are cases like sand mining ban case, the sterilite ban case, and then there are construction ban case. So on the one hand, court has ensured the social rights to be preserved, but on the other hand, there have been economic losses to the Indian economy. So as a matter of principle, what shall be the role of court to ensure the process or also to evaluate the outcomes under all its ambit?
So I think that's it. I don't think we have time, unfortunately, for any more questions. Shimani, maybe you can answer first, since some of the panelists' questions were directly to you.
Very quickly, appellate authorities, yes, citizens can also approach the appellate authorities, though certain appellate authorities have interpreted otherwise, but there's a High Court judgment now that clearly says that people can also approach it. So and yes, I do believe that appellate authorities should be strengthened and make sure that they are actually the first forum to access justice before you go to the National Green Tribunal, but there's a whole big problem there about why that's not happening. About your question about individual rights, it's true that it doesn't happen. Actually, the NGT doesn't even allow individual rights cases to come to it in some cases. But I think theoretically it is possible, but practically you're right that the cases, unfortunately, that the court wants to pay attention to, the media wants to pay attention to, are the ones which have kind of this whole movement around them. But theoretically, individual rights, environmental rights can certainly be brought before the courts. I mean, there is no bar on it.
So on, Manish's question and the other sort of, the form of the PIL question and, the legal strategy, maybe, Namita and Sudhir, do you want to respond to those questions quickly? 30 seconds each. You can respond to the one, you can pick the one you want to respond to.
Okay, I'll also respond to the question about balancing. I think, that's the classic rights dilemma, right? Because rights are abstract and you have multiple rights and competing rights. But I would say that the most important right is the right to life. So if I were to do that balancing, if the pollution levels have reached a level that are so toxic that the right to life is threatened for many people, then I think that would predominate. But of course, that's not always, the balancing has to be done on a case-to-case basis. I think, Manish, you raised very important questions. I think the civil and political rights dimension is, crucial to the adjudication that we are talking about in this space. I mean, speaking about the health rights context, but I think maybe even in the environmental context, these are really authorities that are not doing their job. And particularly in the case of hospitals and the obligations on public-private partnerships and all that, it is really about, enforcing your ability to access these spaces, which they are actually required to do under law, but they're not doing. So in that sense, it's not so much as proactive sort of, rolling out of treatments and things like that. Even in the HIV/AIDS cases, like you already have the money, you already have the programs, just include everyone. So it's really a civil and political rights thing. So I think I'll stop there.
Yeah, 30 seconds, Sudhir.
Two sharp points. On the balancing question, clearly we read about telecom every day in the papers. Whatever else one's views might be on the role of the Supreme Court in telecom, I hope you're rethinking them now. It's clear that courts are not competent to adjudicate this level of complexity in broad policy terms. They're much better off doing discrete small problems which they're institutionally designed to do. And so my view on the broad balancing question is caution and deference. I'd be happy with a court that was like that. On the second question, I don't see, just to be clear, I don't see myself making Anuj's argument at all. I have sharp criticisms of that argument, so I don't want to get into that for the moment. It's not an argument that courts should not engage with social and economic rights. The question that I'm more interested in and that we're interested in the book is to excavate the conditions under which court intervention works or doesn't work. That is the more important question. To pose it as a simple binary, that is, court should intervene, should not intervene, is a mistake. I think it's an intellectual mistake.
So thanks. Thanks. Yeah. Okay. Yeah.
Question on the local authority, because it's an important
Yeah.
one, and that is that I think all of us have in some way or the other talked about the need for citizens to actually be able to engage with the local authorities and use that as a mechanism for, and I think there actually, unfortunately, the courts do have less of a role to play. Even in the Right to Education Act, actually the panchayats have been directly implicated as the grievance redress authority, the first grievance redress authority. But I think that's where the state capacity issue comes into play. And we just haven't built the capacities for those local institutions to take on some of these issues. And so the panchayats actually have been quite upset about the fact that they have been implicated in the Right to Education Act because their own capacities to play a active role in education, even though the Panchayati Raj Act gives it to them, has not been developed. And now to put the grievance redress authority obligation on them actually has put them in a bad spot because they're really unable to. Now, on the state capacity issue, yes, I think the jury is out whether the court can do anything about it. Of course, we need to beef up state capacity, particularly at the local level. Can the courts play a role in that is I think, still an open question.
So, there's lots more to say. Sorry, you can take this conversation outside because the next panel is ready. And we started a bit late, so everything's a little off. But you'll have to take this question outside. So thanks very much to the panelists and to the audience. Thank you.